"Sir, step away from the vehicle. Keep your hands where I can see them." The fluorescent lights of the Chevron station on Route 29 hummed in the late afternoon stillness. The smell of gasoline hung in the air, mixing with the scent of distant rain. Traffic droned on the highway behind them. A Tuesday evening. Unremarkable. Ordinary. "Officer, I'm just filling my tank. Is there a problem?" The man at pump number 7 kept his voice calm, measured. He wore navy slacks and a light blue button-down shirt, sleeves rolled to the elbows. No sudden movements, hands clearly visible. Standard de-escalation. The officer's hand hovered near his service weapon. His radio crackled. Other customers were beginning to notice. Phones came out. "I'll ask the questions. Whose vehicle is this?" What happened in the next 8 minutes would cost a police department its federal funding, trigger a Department of Justice investigation, and expose a pattern of racial profiling that had been hidden for years. To understand how a routine gas station stop became a $41 million federal case, you need to know who was standing at pump number 7 that Tuesday evening. Justice Marcus Whitmore, 58 years old, Associate Justice of the United States Supreme Court. He had graduated summa cum laude from Yale University, Phi Beta Kappa. Harvard Law School followed, J.D., magna cum laude, editor of the Harvard Law Review. He returned to Yale for a Ph.D. in constitutional law, completing his dissertation on Fourth Amendment protections against unreasonable search and seizure. His career spanned 32 years. 8 years as a federal prosecutor in the Southern District of New York, where he maintained a 94% conviction rate on civil rights cases. 12 years as a professor of constitutional law at Georgetown University, where he published 47 peer-reviewed articles. 7 years as a federal appellate judge on the Fourth Circuit Court of Appeals. 3 years ago, the president nominated him to the Supreme Court. The Senate confirmed him 89-8. He had authored landmark opinions on Fourth Amendment search and seizure protections. He was considered the court's leading expert on police conduct and qualified immunity. He had testified before Congress 6 times on law enforcement reform. The Chief Justice had called him one of the most meticulous constitutional scholars to ever serve on this court, with particular expertise in the very amendments designed to protect citizens from government overreach. He had grown up in a working-class Atlanta neighborhood. His father was a postal worker, his mother an elementary school teacher. He'd been married 28 years, 2 adult children. He volunteered teaching constitutional law to high school students in underserved communities. That Tuesday, he just finished delivering a lecture at the University of Virginia Law School. The topic, Reasonable Suspicion and the Fourth Amendment, where training meets reality. The irony would not be lost on anyone. But on May 17, 2023, Justice Whitmore would encounter a police officer who didn't recognize him, didn't verify his identity, and operated entirely on assumptions. An officer with 9 months of experience and a training record that would later raise disturbing questions. Officer Tyler Henshaw, 24 years old, badge number 4472. He'd grown up in a rural area 2 hours from the jurisdiction he patrolled. His father had been a corrections officer before retiring. Henshaw played college football, linebacker, Division III. He earned a criminal justice degree from a regional state university and applied to 6 departments before being hired. 9 months with the department. He'd graduated from the academy in February 2023. The incident occurred in May. He'd graduated 18th out of 24 cadets. He struggled particularly with the constitutional law module, scored 73% when the minimum passing was 70. He excelled in physical fitness and firearms qualifications. He received 1 written counseling during academy training for what his instructor called an overly aggressive approach during a de-escalation scenario. His record showed no commendations in 9 months, unusual for new officers trying to prove themselves. But he'd made 47 traffic stops, above the department average of 32 for rookies. 68% of those stops involved Black or Hispanic motorists. In a district where where they represented 55% of the population. And there was something else in his file. 2 previous complaints, both in just 9 months. March 2023, a black female motorist complained of racial profiling and disrespectful treatment, investigated by his direct supervisor, Sergeant Robert Dawson. Finding: unfounded. April 2023, a Hispanic man complained of extended detention without cause, again investigated by Sergeant Dawson. Finding: unsubstantiated, insufficient evidence. Henshaw's field training officer had noted he sometimes acts on assumptions rather than observable facts. But Sergeant Dawson signed him off for solo patrol anyway. Colleagues described Henshaw as someone who took the job seriously, maybe too seriously. Someone who wanted to be proactive, to catch bad guys before they did bad things. On May 17, 2023, these 2 men, one who had spent 32 years mastering constitutional law, one who had spent 9 months enforcing it, were about to collide at a Chevron station on Route 29. What Officer Henshaw didn't know was that his next decision would be dissected by the Department of Justice, analyzed in federal court, and taught in police academies as a textbook example of how implicit bias overrides training. Tuesday, May 17, 2023, 6:47 p.m. The temperature was in the mid-70s, clear skies, that golden hour light that makes everything look peaceful and normal. Moderate traffic flowed along Route 29. Justice Whitmore had concluded his lecture at the University of Virginia Law School at 5:30 p.m., 90 minutes speaking to 200 law students and faculty. He declined a dinner invitation. He wanted to get home to his family. The Chevron station was directly on his route, approximately 15 miles from his residence. He'd stopped there dozens of times over 3 years. Well-lit, busy location. Safe. He'd been at the pump for approximately 3 minutes, filling the tank of his 2019 Honda Accord, a deliberately modest vehicle despite his Supreme Court salary. 3 blocks away, Officer Henshaw received a dispatch call. 6:44 p.m. Anonymous call from a payphone. Suspicious person at the Chevron station. Male subject, black, acting suspiciously around vehicles. Possible theft or drug activity. No specific vehicle identified. No specific illegal activity observed. No description beyond race and gender. The caller didn't leave a name or callback number. Henshaw arrived within 3 minutes. Single unit response. He didn't request backup or additional information. He'd been 2 hours into his shift. He'd made 1 traffic stop earlier, a warning for a broken taillight. Sergeant Dawson had recently told him to increase proactive policing and make quality arrests. What Officer Henshaw didn't know, the gas station's security cameras were recording. Justice Whitmore's security detail, 2 U.S. Marshals, were stopped for coffee 2 blocks away. And the Supreme Court had just implemented a new policy requiring justices to report any law enforcement encounters. At 6:47 p.m., Officer Henshaw's patrol car pulled into the Chevron station. He observed a black man in business casual clothing standing at a gas pump, filling a sedan. Based on a vague anonymous call and his own assumptions, Henshaw made a decision. Within 8 minutes, that decision would end his law enforcement career and trigger a federal investigation that would expose systemic failures reaching far beyond one rookie cop. Justice Whitmore looked up to see the patrol car pulling directly behind his vehicle, blocking his exit. Odd positioning for a routine check. Officer Henshaw exited quickly. His hand rested on his service weapon, not drawn but clearly positioned. His posture was rigid, fixed stare. "Sir, I need you to step away from the vehicle and keep your hands where I can see them. Now." Whitmore's first thought, comply, stay calm, ask questions. This should resolve quickly. He stepped back from the pump, movement slow and deliberate, hands clearly visible. "Of course, officer, I'm just getting gas. May I ask what this is about?" "I'll ask the questions. Whose vehicle is this? Do you have permission to be here?" The gas pump clicked off behind them. The nozzle hung suspended. Traffic hummed on the highway. This is my vehicle. I've just filled the tank and was about to pay. Is there a problem? Henshaw's jaw tightened. I need to see identification, registration, and insurance. Keep your hands visible. Whitmore reached slowly for his wallet, narrating his movements. I'm reaching for my wallet in my back right pocket, officer. He extracted his driver's license and registration. His business card holder contained his Supreme Court identification card, gold seal clearly visible, official photo, the words Associate Justice embossed at the top. He presented them together. Henshaw took the documents. He barely glanced at the Supreme Court ID. His eyes went straight to the driver's license. Officer, I'm Associate Justice Marcus Whitmore of the United States Supreme Court. That Supreme Court ID is federally issued. You can verify through your dispatcher if needed. Henshaw's expression didn't change. IDs can be faked, sir. I need you to answer my questions. What are you doing in this area? As I mentioned, I'm getting gas. I live 15 miles from here. I've stopped at this station many times. This is my regular route home. This area has had reports of suspicious activity. You match a description. I need to verify you're not involved. Other customers were watching now, phones out, recording. What description specifically? What suspicious activity? What crime are you investigating? Whitmore kept his voice calm, professional, but he could feel the absurdity of the situation crystallizing. Officer, I need to be clear. I'm exercising my Fourth Amendment rights. You've detained me without articulating reasonable suspicion of any specific crime. I'm pumping gas at a public gas station. What reasonable suspicion do you have? Henshaw's frustration was visible. Sir, I don't need to explain myself to you. I'm conducting an investigation. If you have nothing to hide, just cooperate. Cooperation doesn't mean surrendering constitutional rights. Terry v. Ohio requires you to articulate specific and articulable facts suggesting criminal activity. What facts have you observed? Look, I don't know where you learned to talk like a lawyer, but out here, I need you to just answer questions and cooperate. Don't make this difficult. I'm being completely cooperative. I've provided identification including federal credentials. What specific action of mine suggested criminal activity? You were reported as suspicious. That's all I need. Now I can do this the easy way or the hard way. Whitmore felt frustration mixing with professional assessment. He was witnessing the exact scenario he lectured about. This officer was making career-ending mistakes in real time. Whitmore made a calculated decision. He spoke slowly and clearly, aware of the body camera. Officer Henshaw. He read the name tag. I am Associate Justice Marcus Whitmore of the United States Supreme Court. I was appointed by the President and confirmed by the Senate. I adjudicate constitutional law, including Fourth Amendment cases involving police conduct. I am asking you directly, what reasonable, articulable suspicion of criminal activity did you observe? 5 seconds of complete silence. Henshaw's face registered confusion, then disbelief, then visible panic. I need to verify. I encourage you to verify. Call your supervisor. Contact Federal Protective Services. But I also need your badge number, and I need to know if you're continuing this detention. Henshaw stammered. Sir, I'm just doing my job. The call said suspicious person. You were here alone. I was pumping gas. At a gas station. In business attire. With federal identification. For 3 minutes. Please articulate what was suspicious about that specific behavior. A backup unit pulled into the station. Officer Maria Santos, an 8-year veteran, exited her vehicle. She took one look at Justice Whitmore. Her expression, visible shock. Officer Santos approached quickly, recognizing immediately that the situation was not what the dispatch call suggested. Whitmore's voice remained calm, professional, but each question landed like a hammer blow. Officer Henshaw, did you observe me commit any traffic violation? No, sir. Did you observe me engage in any criminal activity? The call said suspicious. Did you observe any action that a reasonable officer would consider criminal? A long pause. You were alone at the pump. Did you attempt to verify the anonymous caller's claims before initiating this stop? I responded to the call as dispatched. Did you run the vehicle's registration before approaching me? No, sir. Did you observe any weapon, contraband, or evidence of a crime? No. So your reasonable suspicion was based entirely on an anonymous call describing a black man at a gas station. Is that accurate? Silence. Officer Santos intervened quietly. Tyler, let me handle this. But Whitmore wasn't finished. He was creating a record for the body camera, for the investigation he knew was coming. This stop violated the Fourth Amendment's prohibition on unreasonable seizure. Terry v. Ohio requires reasonable suspicion based on specific and articulable facts. An anonymous call without corroboration doesn't meet that standard. That's Florida v. JL, decided in 2000. You detained me without legal basis. Henshaw's defensive response. I was following training. We're supposed to investigate suspicious calls. Investigate, yes. Detain without reasonable suspicion, no. Those are fundamentally different actions under constitutional law. Your department's own General Order 240 requires verification of anonymous tips before initiating stops. Did you follow that policy? A black SUV pulled into the station. Two men in plainclothes exited, showing federal credentials. U.S. Marshals, Justice Whitmore's protective detail. The lead marshal approached. Officer, we're Justice Whitmore's protective detail. We need to understand what's happening here. Henshaw's face drained of color. The magnitude of his mistake was now undeniable. Whitmore stated clearly for the body camera record. Officer Henshaw, I will be filing a formal complaint with your department. NT and notifying the Administrative Office of U.S. Courts. Officer Santos, I'd like your badge number as a witness. This stop was unconstitutional, and given the lack of articulable suspicion, I have concerns about the pattern of stops in this jurisdiction. Officer Henshaw returned to the station at 7:15 p.m., 30 minutes after the encounter ended. Watch Commander Lieutenant Patricia Chen was waiting. She'd already reviewed the body camera footage. Her expression said everything. My office now. Henshaw sat across from her as she played back the footage. His own voice on the recording, his inability to articulate reasonable suspicion, his dismissal of federal credentials, his continuation of the detention even after being told he'd stopped a Supreme Court justice. You stopped a Supreme Court justice without reasonable suspicion after he identified himself, and you continued the detention. Are you understanding what you've done? Within 90 minutes of that conversation, Henshaw was placed on immediate administrative leave. Badge and service weapons surrendered, required to remain available for interview. Justice Whitmore, meanwhile, drove home. At 7:45 p.m., he contacted the Supreme Court's Marshal Service. At 8:30 p.m., he filed a formal complaint with the police department, a 4-page detailed account with precise timestamps. He notified the Administrative Office of U.S. Courts. He did not contact media. Judicial ethics required discretion. Police Chief Daniel Morrison received a call at home at 8:15 p.m. He returned to headquarters immediately. He watched the body camera footage 3 times. At 9:30 p.m., he personally called Justice Whitmore to apologize and inform him of Henshaw's administrative leave. Whitmore's response was immediate. Chief, this isn't about an apology to me. This is about a constitutional violation. How many others has this happened to who don't have federal credentials? The Supreme Court Marshal Service contacted the FBI Civil Rights Division at 9:45 p.m. Protocol for potential civil rights violations against federal officials. Gas station security footage and cell phone video from bystanders began circulating on social media by 10:30 p.m. The hashtag, #GasStationJustice. When Chief Morrison reviewed Henshaw's personnel file that night, he found the 2 previous complaints. Same pattern, both investigated and dismissed by Sergeant Dawson, both involving people of color, both with similar suspicious person justifications. Chief Morrison made a decision that would determine his department's future. He didn't bury it. He requested an independent investigation. What that investigation uncovered over the next 8 weeks would expose not just Officer Henshaw's pattern, but Sergeant Dawson's protection of it, and a department culture that prioritized statistics over constitutional policing. 3 simultaneous investigations launched. Internal Affairs opened its investigation within 24 hours. The FBI Civil Rights Division opened a federal criminal investigation for potential violation of civil rights under color of law. The Department of Justice Civil Rights Division launched a pattern and practice investigation. Internal Affairs completed its work in 8 weeks. Captain James Rodriguez, a 20-year veteran and former Internal Affairs commander, led the investigation. The FBI investigation took 4 months. Special Agent Monica Tran, 12 years with the Civil Rights Division, headed the federal probe. The DOJ investigation lasted 11 months. Attorney Sarah Mitchell, who had led 3 previous police pattern investigations, supervised. They reviewed everything. All 47 of Henshaw's traffic stops, approximately 28 hours of body camera footage, every dispatch record, response time, and radio communication from his 9-month tenure, complete training records, academy performance evaluations, field training officer notes, computer-aided dispatch data showing geographic mapping of stops, demographic breakdowns, stop duration analysis. They interviewed 23 people. Justice Whitmore provided a 4-hour recorded statement and detailed legal analysis of the constitutional violations. He waived privacy protections regarding his own stop. He specifically requested the investigation extend beyond his case to examine patterns. Officer Henshaw was interviewed twice, represented by his police union attorney. He maintained he followed training and didn't see race. He claimed the anonymous call was sufficient justification. He could not explain why his stop patterns showed demographic disparities. What the investigators found was damning. Henshaw's 47 stops in a jurisdiction that was 45% white, 30% black, 25% Hispanic, and other demographics broke down this way. 32 stops, 68% of black or Hispanic drivers. 15 stops, 32% of white drivers. The DOJ's statistical analysis. Henshaw stopped black drivers at 2.3 times the rate expected based on population and traffic patterns. Geographic analysis showed 38 of 47 stops occurred in 3 specific neighborhoods, the most diverse areas of the jurisdiction. Duration disparities. Average stop of black drivers lasted 14.2 minutes. Average stop of white drivers lasted 6.7 minutes. The investigators reached out to the 2 previous complainants. Tanya Williams, 34, a black accountant, stopped in March 2023 while driving home from work. Henshaw claimed she looked suspicious in the neighborhood where she actually lived. The stop lasted 22 minutes. No citation, no warning. She filed a complaint. Sergeant Dawson investigated. Finding: unfounded. Officer was conducting legitimate investigation. Complainant was uncooperative. The body camera footage showed Williams calmly asking legitimate questions about the basis for the stop. Carlos Mendez, 41, a Hispanic construction company owner, stopped in April 2023 while leaving a job site. Henshaw asked, "Do you work around here?" despite Mendez wearing a company uniform with his business name embroidered on it. The stop lasted 18 minutes. Henshaw searched the vehicle. Mendez never gave consent. Henshaw claimed plain view of suspicious items that turned out to be work tools. Mendez filed a complaint. Sergeant Dawson investigated. Finding: unsubstantiated, insufficient evidence to prove misconduct. The body camera clearly showed the search without consent. Every complaint had been investigated by Sergeant Robert Dawson, Henshaw's field training officer, his direct supervisor for all 9 months. The DOJ expanded its investigation to the entire department's stops over 3 years. Black drivers were 1.7 times more likely to be stopped than white drivers department-wide. Black drivers were 3.2 times more likely to be searched during stops. But the hit rate, the percentage of searches that actually found contraband, told the real story. Searches of black drivers found contraband 18% of the time. Searches of white drivers found contraband 31% of the time. The lower hit rate indicated a lower threshold for searching black drivers. The investigation identified 67 stops over 3 years initiated based on anonymous calls. Only 12 involved verification attempts before detention. The findings were unequivocal. In Whitmore's case, Fourth Amendment violation, detention without reasonable suspicion based on specific articulable facts. Department General Order 240 violation, failed to verify anonymous tip. Department General Order 180 violation, continued detention after identification and explanation provided. The DOJ report characterized Henshaw's stops as consistent with pretextual racial profiling, and Dawson's investigations as insufficient, biased, and designed to protect officers rather than ensure accountability. Professor David Chen from Stanford Law reviewed all the evidence. His conclusion: this is a textbook example of implicit bias manifesting in police work. Officer Henshaw likely didn't consciously think, "I'm going to target black people," but his stop patterns reveal decision-making consistently influenced by race. The stops aren't based on behavior, they're based on presence. U.S. Attorney Rebecca Hall put it more bluntly. A Supreme Court justice with federal identification was detained for pumping gas. If this can happen to one of the most powerful people in the legal system, what's happening to everyone else? The DOJ investigation report stated, the pattern of stops, the dismissal of complaints, and the supervisory failures represent not individual bias, but institutional tolerance of constitutional violations. This department prioritized stop statistics over constitutional compliance. The investigations concluded with unanimous findings: constitutional violations, supervisory failures, and a department culture that enabled discriminatory policing. The recommendations were clear. Officer Henshaw should be terminated. Sergeant Dawson should be demoted or terminated. The department should implement comprehensive reforms. But the consequences would extend far beyond 2 careers. They would cost the department millions and transform how it operates. Officer Tyler Henshaw was terminated 43 days after the investigation concluded. The police union initially contested the termination, standard procedure. An arbitration hearing was held in August 2023. The 3-member panel voted 3-0 to uphold the termination based on constitutional violations and a pattern of problematic stops. Effective termination date: September 1, 2023, 3.5 months after the incident. The FBI referred the case to the U.S. Attorney for potential federal criminal charges. After review, no federal criminal charges were filed. The determination: the violation didn't meet the willful standard required for criminal civil rights prosecution, but the findings noted reckless disregard for constitutional rights. Justice Whitmore filed a federal civil rights lawsuit in June 2023 under 42 U.S.C. Section 1983. He named Henshaw individually, Sergeant Dawson for supervisory liability, and the Department for municipal liability under the Monell Doctrine. The case settled in March 2024, $850,000 to Justice Whitmore. Henshaw's personal liability, $50,000, paid through insurance and personal funds. It was unusual for a Supreme Court justice to pursue damages. Whitmore stated, "This is about accountability and establishing precedent for everyone else." The State Peace Officer Standards and Training Commission held a hearing in October 2023. They revoked Henshaw's law enforcement certification. He cannot work as a police officer in the state. The decertification is recognized by 43 states through an interstate compact. His law enforcement career was effectively ended nationally. Henshaw reportedly moved to a different state. He's working in private security, unarmed. His marriage ended in November 2023, divorce documents citing stress from the termination. He filed for bankruptcy protection in April 2024. He released a statement through his attorney. "I regret the encounter and any appearance of bias. I believed I was following my training. I've learned from this experience." No direct apology to Justice Whitmore. Sergeant Robert Dawson faced his own reckoning. The DOJ found he deliberately ignored evidence of constitutional violations to protect an officer he trained, and failed to properly investigate 3 separate complaints showing a clear pattern. Chief Morrison recommended termination. After union arbitration, Dawson accepted demotion to patrol officer rank, losing supervisory authority and a significant portion of his pay. 30-day unpaid suspension, mandatory retraining, a permanent notation in his file prohibiting future supervisory or training roles. The demotion reduced his pension calculation, which is based on the highest 3 years of salary. He was eligible for retirement but chose to remain. He reportedly needed 2 more years for full pension. He's currently working patrol shifts with no subordinates, scheduled to retire in 2026. The financial toll on the city was severe. $850,000 in settlement to Justice Whitmore, $340,000 in outside legal counsel fees, $180,000 for independent investigation costs and DOJ cooperation. The Department of Justice suspended $4.2 million in federal grants pending implementation of a consent decree. The Community-Oriented Policing Services Grant, $1, $8 million, frozen. The Edward Byon Memorial Justice Assistance Grant, $2, $4 million, frozen. The grants would only be released upon verification of reform implementation. 11 other plaintiffs filed civil rights lawsuits citing similar stops. 8 cases settled for a combined $2.1 million. $3 are still pending. The department's liability insurance premiums increased 340% for the following policy year. Consent decree compliance costs, $3.7 million over 4 years for required technology, training, and independent monitoring. Total direct costs, approximately $11.4 million. The $41 million figure represents combined settlement costs, suspended federal funding over the 3-year consent decree period, compliance costs, insurance increases, legal fees, and projected costs for ongoing investigations and audits through full compliance in 2028. But numbers don't tell the whole story, the reforms do. All complaints involving potential bias are now investigated by an independent panel, 2 officers from other departments and 1 civilian. Conflicts of interest like Dawson investigating his own subordinate are explicitly prohibited. Complaints are tracked in a statewide database accessible to the Post Commission. Body camera footage must be reviewed within 72 hours of any complaint filing. A civilian review board was created with subpoena power. 7 members appointed by the City Council, not police selected. A federal monitor, a former FBI civil rights investigator, was appointed for 4-year consent decree compliance. Quarterly reports to the DOJ are required through 2028. Independent audits of stops occur every 6 months with full demographic analysis. An early intervention system now tracks 14 metrics per officer: stop demographics versus population benchmarks, stop duration disparities, search rates and hit rates by demographics, complaint patterns, use of force incidents, supervisor counseling sessions. An algorithm flags any officer exceeding thresholds. For example, officers with 1.5 times disparity in stops by race trigger mandatory review within 5 days. Body camera policies were enhanced. Mandatory activation for all public encounters, previously it was discretionary. Supervisors conduct random reviews of 5% of footage weekly. Complaint-related footage is automatically forwarded to the Civilian Review Board. A public access portal was created for footage requests, released within 14 days unless an investigation is pending. General Order 240 was revised. Officers must attempt verification before initiating detention based on anonymous calls. Dispatcher scripts were updated to gather more information. Can you describe specific behavior that appears criminal? Anonymous calls without specific criminal behavior descriptions are classified as information only. No detention authority. Training curriculum was overhauled. 40 hours of new mandatory training. 8 hours on implicit bias recognition and mitigation. 12 hours of constitutional law refresher taught by law professors and civil rights attorneys. 8 hours of de-escalation and verbal communication. 6 hours of community policing. 6 hours of scenario-based training with diverse actors. Body cameras are used in scenarios, then reviewed and critiqued. Annual recertification requires 16 hours ongoing. Supervisors are now personally liable for failing to identify and address subordinate patterns. Promotion to supervisor requires implicit bias testing and demonstrated constitutional knowledge, written exam, oral board, scenario assessment. Supervisors are evaluated partially based on subordinate complaint rates and resolution. Failure to supervise is explicitly listed as a terminable offense. Mobile data terminals were upgraded to include instant credential verification systems, database access to federal employee identification with privacy protections, facial recognition for official government IDs, federal, state, judicial officers, allowing verification during stops. A new policy was created and named after the case, the Justice Whitmore Protocol. Officers must attempt credential verification before extending detention when federal or state identification is presented. The protocol requires supervisor notification within 10 minutes if credential verification is inconclusive. The department reviewed all stops from the previous 3 years. 8,400 stops analyzed. 127 additional potentially problematic stops identified. 23 referred for further investigation. 4 additional officers disciplined with suspensions ranging from 5 to 20 days. The city established a $500,000 victim compensation fund for individuals impacted by unconstitutional stops. 41 claims filed. 28 approved. $380,000 paid out. Monthly town halls were initiated. An advisory committee with community representation was formed. A transparency dashboard now shows stop data publicly. The case became a national case study. It's incorporated into federal law enforcement training centers' curriculum. The DOJ used the investigation as a model for 3 subsequent pattern and practice investigations. 17 police departments nationally voluntarily adopted elements of the consent decree reforms. The ACLU cited the case in policy briefs submitted to 12 state legislatures considering police reform bills. The case has been featured in 34 law review articles and 9 criminal justice research papers analyzing implicit bias in policing. Justice Whitmore, maintaining judicial ethics boundaries, participated in 3 anonymous academic roundtables on police reform. He provided body camera footage with personal identifiers redacted to be used in training. He declined paid speaking engagements but spoke at 2 police academy graduations about constitutional policing. Nearly 2 years after that May evening at a Chevron station, the reforms are working. Stop disparities have decreased by 41%. Complaints are down 37%. And importantly, complaint resolution trust has increased. 72% of complainants now express satisfaction with the investigation process, compared to 23% before the reforms. But the case's most important impact might not be measured in statistics. It's measured in the thousands of officers now trained differently, the communities now trusting more, and one Supreme Court justice who turned a personal injustice into systemic change. Justice Marcus Whitmore still serves on the Supreme Court. Last term, he authored the majority opinion in another Fourth Amendment case involving police stops. During oral arguments, he cited his own experience, unprecedented for a sitting justice. He continues teaching constitutional law to high school students. He maintains his modest lifestyle. He still occasionally stops at the same Chevron station on Route 29. The body camera footage from that stop, with his permission, identity partially redacted, is now used in over 180 police academies nationwide. The Case app appears in 12 criminal justice textbooks in their 2024 and 2025 editions. An independent 18-month review in March 2025 showed measurable improvement. Stop racial disparity decreased from 1.7 times to 1.2 times, closer to the one benchmark indicating proportional stops. Search disparities decreased from 3.2 times to 1.6 times. Hit rates equalized. Contraband found in 24% of black driver searches versus 26% of white driver searches, a statistically insignificant difference. The Federal Monitor noted, significant progress, continued oversight warranted. The case is now used in law schools to teach civil rights litigation, in police academies to demonstrate constitutional violations, and in implicit bias training across professions. What the case revealed: even highly trained officers with stated good intentions can engage in racially disparate policing when systems don't track, identify, and address patterns. Supervisors play critical gatekeeping roles in either enabling or preventing bias. The universal lesson: credentials, expertise, and even extraordinary authority don't shield anyone from being profiled. If a Supreme Court justice can be detained unconstitutionally based on an anonymous call and race, anyone can be. The Fourth Amendment exists precisely for moments like these. Police must have reasonable suspicion based on specific articulable facts, not vague hunches, not anonymous calls without corroboration, not presence in a location. Body cameras protected Justice Whitmore by documenting his innocence. They protected good officers like Santos by showing their professionalism, and they exposed constitutional violations with irrefutable evidence. Individual punishment alone doesn't fix systemic problems. Reforms targeting training, supervision, oversight, and data tracking address root causes. This case connected personal experience to systemic investigation, translated into measurable reforms, and created national precedent for accountability. Justice Marcus Whitmore still stops at that Chevron station on Route 29, same pump he was standing at on May 17, 2023. Same Honda Accord, now with 47,000 more miles. Same routine drive home from speaking engagements about constitutional law. But when officers from that department drive past now, and they do, regularly, they don't see a suspicious person. They see the case study from their training. They see the $11.4 million lesson in what happens when assumptions override observation. They see the civilian review board that now investigates complaints. They see the early warning system tracking their own stop patterns. Officer Henschel saw a black man at a gas station and assumed criminality. The body camera recorded 8 minutes that would prove him wrong, cost him his career, and expose a department culture that had protected bias for years. Assumptions based on race have consequences. Evidence doesn't lie, bias does. And accountability, real accountability, ends with one firing. It ends with systems that prevent the next one. If this story opened your eyes to how implicit bias operates even in trained professionals, or helped you understand your constitutional rights during police encounters, share it. Cases like this reach people who need to see them when engagement shows platforms they matter. And if you've experienced something similar, or you're in law enforcement working to do this better, your perspective adds to this conversation. This channel documents accountability, not just outrage but outcomes. Investigations, reforms, long-term follow-up. If that approach resonates, you know what to do. Thanks for watching Bodycam Truth Files.